Mr. Dawson, you've been convicted of reckless driving before.
Objection, Your Honor. May we constructively approach?
You may.
Your Honor, pursuant to Rule 404B, this is trying to go into prior bad acts. Counsel's trying to use a prior conviction to show action conformity therewith. It's inadmissible character evidence, Your Honor.
Your Honor, we're not using this evidence to show action in conformity therewith. One of the elements of our burden is to show that the defendant was aware of the risks that he was taking. One of the best ways to show that is that he's had run-in with the laws before and knows how dangerous these types of actions are. We're willing to submit to a limiting instruction to the jury that this evidence is not to be taken for action in conformity and only for the knowledge and the awareness that the defendant had.
Your Honor, may I respond?
You may.
Your Honor, this is still being used to show action conformity therewith. Furthermore, Your Honor, this information is more prejudicial than it is probative. It does not aid the jury to know that he had a previous run-in with the law. Furthermore, Your Honor, if it's not specifically going to his knowledge of Canyon Road that night, then it has no probative value. Whether or not he had a run-in with the law dealing with another road, another street, or any other circumstance, if it does not specifically go to his conduct on Canyon Road, it cannot go to his knowledge of the dangers of Canyon Road. Therefore, it does not go to the charge that's being put forth in front of the jury, and it has no probative value.
Actually, Your Honor, as I expect that the facts will show, the previous conviction that the defendant had not only involved alcohol, but it also involved some of the streets that we're talking about today. I expect that the facts will show that it was at Chuggy's when he was coming from when he got this previous conviction. Like I said, Your Honor, we in no way intend to use this to show action in conformity therewith. That's the only reason it would be inadmissible.
There might be some probative value, but I'm not going to allow it in because I believe it's more prejudicial than probative, so. Stay.
Mr. Dawson, Vanessa gave you a ride home from school that weekend.
I believe she did, yes.
And the two of you made a deal.
What are you speaking of?
You made a deal with her that you would be the designated driver that night in return for getting a ride home.
She mentioned...
Objection, Your Honor, this question calls for hearsay. While what Mr. Dawson said himself may be part of admission by a party opponent before not hearsay, the deal means that both of them had to discuss it. Vanessa Sullivan's part is hearsay and is inadmissible here today in court.
Your Honor, we're not offering for this for the truth value of the matter, only the effect that it had on the listener. The reason that we want this evidence in is because the defendant was under the belief that he would be the designated driver that night. So we don't need that to actually be true, just that he believed it. That's why we're offering those statements.
I'll allow it overruled.
Your Honor, I ask that a limiting instruction be given to the jury that this is not for the truth of the matter, therefore it's not being offered as truth, only that this may have been said in the car.
The jury is so instructed.
Mr. Dawson, you made a deal with Vanessa to be the designated driver in exchange for a ride home.
No, it was not a concrete deal. She mentioned something that I might have to be the designated driver, but there was no way a set agreement that I was going to.
Well, actually, Mr. Dawson, you agreed to those terms.
I said in my affidavit that she mentioned something that I might have to be the designated driver.
You said to her that you would be willing to be the designated driver on the night of her birthday party.
Objection, Your Honor, this question's been asked and answered twice before. This is the third time the witness keeps answering it. He did not in fact say that.
Your Honor, that this is a different question, and the witness hasn't actually yet answered the question.
I'll allow it, but make sure you don't keep repeating the same question.
Yes, Your Honor.
I had mentioned that I would be willing if the opportunity was needed.
Mr. Dawson, the very next day, a cab driver offered you a ride home for later in the evening.
Yes, that is correct.
You told him you were pretty sure you wouldn't be having to drive that night.
That's correct.
Mr. Dawson, you were so sure that you wouldn't have to be having to drive that night that you weren't worried about drinking.
That is absolutely not true.
Mr. Dawson, is it your testimony that you were worried about your drinking?
I'm not saying that I was completely not worried about my drinking. I tried to stay to my standard of 1 drink per hour.
But Mr. Dawson, you didn't believe you'd be driving home?
I did not.
So you were not worried about how many drinks you had that night?
I tried to stay to my standard, but I was not worried per se.
You were not worried per se. And that's the reason that you had 10 or 11 drinks that night.
Like I said, 1 drink per hour, as I normally do.
Because in your own words, Mr. Dawson, this night was a night of celebration.
For Vanessa, yes,
Nothing was going to kill your buzz that night.
that's ridiculous.
Have you not said that before?
I don't believe so.
Mr. Dawson, has that always been your testimony? That nothing was going to kill your buzz on this night of celebration?
If you're referring to a buzz from alcohol, I disagree. I was excited for Vanessa's celebration. I was not excited to get buzz from alcohol.
Okay, Mr. Dawson. Later that night, your server offered to call you a cab.
Judge, Your Honor, hearsay. Pursuant to Rule 801, this is an out-of-court statement being offered to prove the truth of the matter asserted.
Your Honor, we're not offering this for the truth of the matter, only for the effect on the listener. The fact that the defendant believed that there was a cab available is what's important here. And the fact that he consciously disregarded the risks of driving home is what's important. Not the fact that Ms. Lawrence actually knew that there was a cab available.
Overruled.
Your server offered to call you a cab.
That's correct.
In fact, there was a cab driver waiting outside that offered you a ride.
Yes, same line.
You turned down all those offers for a ride home.
Yes, like I said, I was sober at the end of the night.
Mr. Dawson, when you got in that car to drive home, you pulled out a radar detector.
That's correct. Vanessa had one.
You flipped it on,
I did.
took off down the road.
Yes, I drove away.
You took Canyon Road.
Yes, that's the way I was told to take.
Actually, Mr. Dawson, you took Canyon Road because you knew that there would be fewer police officers on that road.
Judge, Your Honor, that's not a question. Counsel just made a statement. It's argumentative, Your Honor.
Your Honor, the witness can say yes or no to whether or not he actually did believe that.
Overruled.
You took Canyon Road, Mr. Dawson, because you knew there would be fewer police officers.
That's correct. I knew there was...
You knew that it would be a more dangerous
Judge, Your
route.
Honor, he just cut off the witness in the middle of his answer.
The witness was finished answering.
Overruled.
You knew that Canyon Road was more dangerous than other routes you could take.
Yes, I did know about the dangerous section.
And you took it anyway to avoid law enforcement officers.
Yes, that was the area of the road.
Are you still going to tell us that you don't think you were doing anything wrong?
Judge, Your Honor, this is completely argumentative.
Sustained.
We ask that the question be stricken from the record and the jury be asked to disregard.
Jury is so instructed.
Mr. Dawson, you sped on your way home that night.
I did speed, yes.
You intentionally sped because you wanted to get Vanessa home on time.
That's correct. I didn't want her parents to get angry at me.
Mr. Dawson, at one point, that radar detector lit up.
Yes, it did.
It told you basically that you were about to pass a police officer.
That's correct.
You slowed down as you passed that cop.
Yes, I did.
Because you were worried that at the speed you were going to get pulled over.
That may have been a possibility, yes.
And then after you passed that police officer, you sped back up.
A little bit, yes.
And you started taking those curves faster.
Yes.
Mr. Dawson, it was dark.
Yes, it was.
It was pouring down rain.
It was raining a lot, yes.
And you were speeding around those curves to get Vanessa home on time.
I was trying to drive quickly enough to get Vanessa home in time.
In fact, you intended to make it in half the time that it takes for a law-abiding citizen to take that route.
Yes, that was my intention.
And then you lost control of the car.
No, actually, I saw the deer, I swerved to the right, overcorrected, and then lost control of the car.
And it was after you lost control of the car that you hit a tree.
That's correct, yes.
You hit a utility pole.
Yes.
Vanessa was killed.
Yes.
And then, Mr. Dawson, you were asked to take a breathalyzer test.
Yes, I will.
Now, you know what a breathalyzer test is, right?
Yes, sir. I do.
You're familiar with the procedure? You blow into it and it's supposed to tell you what your blood alcohol content is?
Yes, sir.
And you were advised of your rights in taking that breath alcohol content.
Yes, sir.
You were advised that if you refused to take it, it would be held against you as evidence of your guilt.
Objection, Your Honor, this is hearsay. Furthermore, Your Honor, there's no evidence to back up this statement that he was advised to. Your Honor, the proper foundation hasn't been laid that if he was advised that he would, this would be held against him in court. They have not laid any foundation to say that this was actually said. They have not laid any foundation to say who actually said this to Mr. Dawson.
Your Honor, let's take those objections one at a time. The first was to hearsay, but this is not being offered for the truth of the matter asserted. The important part about these statements is that the defendant was aware that this would be used against him in court, and he went ahead and did it anyway. As to lack of foundation, there's not any foundation needed to enter this evidence. We're just asking whether or not that statement was made. So there's really no foundation that needs to be laid. The witness can say that it's true or say that it's not true, whether or not it is.
Objection is sustained.
Mr. Dawson, you refused to take that breathalyzer test.
That's correct. I exercise my right.
I pass the witness.
Brief redirect. Mr. Dawson,